We are moving into the second half. We're going to talk about overlaps between design patents and other areas of intellectual property protection. And I want to turn it over to our co-sponsor, Jamie Lemons at Nike.
Thank you so much. So unlike the last panel, I think we'll just start by introducing ourselves, and then I'll set up the framework after that. So I'm Jamie Lemons. I am a trademark attorney at Nike. I've been there for a little over 4 years now, and have some minor crossover with Katie, who talked earlier, but really mostly focus on trademarks and have from the beginning. So very interested in all the information from this morning, and very much looking forward to this panel as well.
Hi, I'm Robert Katz from the law firm of Banner & Witkoff in the DC office. I've been with the firm since 1992. Very fortunate to represent a number of design-driven clients, and we've been rather active in the design procurement enforcement field because of that. Close to 90% of my practice is focused on designs. I currently teach a pre-litigation course at Georgetown University, and also teach design law at George Washington University.
I'm Laura Hammond. I'm on the faculty at William & Mary Law School in Williamsburg, Virginia. Teach copyright law and trademark law. I also teach first-year courts. Before that, I was in a 2-year fellowship at GW, and before that, I was in-house at America Online. I was there for about 3 years, and before that, was at what was then Wilmer, Cutler & Pickering in DC.
Thank you. I'm Tom Moga. I'm a partner with the international law firm of Shekardi Bacon. I lived and worked in China for a while, and my portfolio, my work is actually opposite Rob's. I'm 90% invention. My background's biochem, but I do get the 10% working in the design area, copyright, mostly in China, where we strategize to develop portfolios and figure out how best to fill in gaps left by the law.
I'm Mark McKenna. I teach at the Notre Dame Law School in South Bend, Indiana, or as Eric Goldman likes to say, flyover country. So I teach pretty much across the range of IP at Notre Dame, since I am the Notre Dame Law IP faculty. I've taught kind of the full range. Most of my scholarship has in the past been kind of focused in the trademark area, but also some on areas in which IP law, different IP regimes intersect with each other. Prior to being at Notre Dame, I was at St. Louis University, and then I, before that, was practicing at a firm called Patterson McAuliffe in Chicago, which, if you have some trademark experience, you might know.
Great.
Okay.
Well, to set up, we're not going to have any PowerPoints today, and how we envision the panel is really to have an open discussion between the 5 of us, and really encourage anyone to jump in throughout the conversation. If you have comments or questions, we will reserve a little time at the end as well to make sure we cover everything off. But please feel free to jump in as we go along. And our intention today is to give a brief introduction to the ways the different IP rights overlap, and then go into sort of a practical discussion of how private practice and in-house attorneys can really be maximizing the different IP protections and what risks may lie in claiming multiple protections as well. Then have a real policy discussion of where do we see the law going in the future? Is the state of the law now right? What changes might we like to see made? And then lastly, we'll try to bring in really what Tom spoke about just then, which is let's take a look outside the U.S. for a bit, and what overlapping rights are there outside of the U.S. that we should be thinking about at this point. So with that, I'll turn it over to Laura to launch into the initial framework.
Great. Thanks, Jamie. So I'm going to start with just a little bit of some of the case law background, just to provide a framework for some of the discussion that we'll be having. One of the things we're thinking about as we go through this discussion this afternoon is about the question of why we might care about overlapping rights, overlapping regimes, and part of that is going to be driven, I think, by which side of the V you might find yourself on, right? So from an intellectual property owner's perspective, the idea that there might be overlapping rights might not be so much of a concern, right? There's sort of might be a belt and suspenders form of enforcement, right? The idea that there's availability under more than one regime and that you should, on behalf of your client, try to seek as much protection as you can under the law. If you're somebody who is a competitor or somebody looking to sort of use some of these rights, you might have a different view on the nature of overlapping rights. Or if you're trying to clear rights for a client and you're concerned about, well, if we have a design patent the term of which has expired, does that mean then that my client can then make the thing that is the subject of that design patent, right? Use that design on a future industrial good, or are there now trade dress rights that still need to be worried about there? And we've seen a little bit in the discussion that we had this morning about different ways that we might approach the question, right, of if we need to alter this regime at all. Do we do it through some of the doctrines that we talked about in the previous discussion, right, to try to draw lines between the various regimes? Do we think about this in terms of remedies? We've seen a way in which the fact that we have overlapping regimes causes some of the, for example, the tests to bleed from one to another. So we saw how Morton Norwich now, where we had over in the trade dress, sort of in the functionality realm over in trademark, now starts to be picked up by some of the courts in the design cases. We see the courts in design patent cases talking about the harm to be prevented as, or the question that we're ultimately trying to answer is, will consumers be deceived into thinking that the defendant's design is the same as the plaintiff's? And this idea of deception almost seems like it should be foreign to the question of design patent infringement. Right? A deception as to whether you're getting the plaintiff's design or the defendant's design seems to be something that we would be talking about over in the trade dress side. So we've got a lot of ways in which the overlap of doctrines leads to an overlap in the way we think about the rights and the way we talk about the rights. So brief overview then of the case law to sort of situate things, and then I'll turn it over to Mark to talk a little bit more about channeling doctrines. So with some early decisions, early 20th century decisions in which the courts had held that even though an owner could qualify for rights under one regime or another, you had to elect, right? And so this might be another election, might be another way in which we might say we would want to, if we do, have in the scope of these rights, is to say you are eligible to choose one or the other, but you have to elect one. So we had an early case, Louis de Jong, a 1910 circuit court case, and the defendant tried to defend against a copyright infringement claim for a design by saying, well, this design was intended for use on wrapping paper, and so you shouldn't have been protecting this under design law. It was illegitimate for you to protect this under copyright. And the court rejected that argument, right, saying that you had to go into one regime or another. But the court there, remember this is a 1910 case, said, but you can't go into both, right, that there are different regimes here with different methods of protection. And so once you decide, you then have to abide by that decision. And we saw the same thing in a 1927 appellate case, In Re Blood, held similarly, where this now was the choice between design patent and trademark for a label, basically. And the court said the same thing there. You can choose which one you want, but once you've chosen, you can't do both. You pick your course, and then you're sort of bound by that. But as many of you know, by the time we get to the mid 20th century, in 1964, the In Re application of Mogan David wine, where we have the question of a wine decanter, which was refused registration for trade dress in the principal register because the plaintiff already had a design patent for the same design, and the question was that legitimate, right? The TTAB had refused registration on the principal register because of the existing patent, and the Court of Customs and Patent Appeals said, no, that's not an issue. The trademark rights are different rights from the patent rights. The termination of the design patent is going to have no legal effect on the rights under trademark law. In fact, it said in sort of a very strong statement, patent expiration is nothing more than the cessation of the patentee's right to exclude, held under the patent law. And so we don't think that the expiration of one has anything to do with the expiration of the other. And we saw the same thing from the court, that same court, in the Emery Yardley case. As you might remember, this is now the design patent for the ornamental design of the Spiro Agnew watch face. And again, the denial there below was on the fact that there were already existing copyright registrations. And the court said that shouldn't matter at all, right, to the question of whether or not there could also be a design patent for the same design. And so by 1993, we get the Seventh Circuit saying in the Kohler versus Moen case involving the faucets that it's clear that a product's different qualities can be protected simultaneously or successively by one or more of the statutory means for intellectual property. Right? And again, there we had a question about whether there could be both trade dress rights and design patent rights in the faucet handle design, and the court rejected the idea that if you accord trade dress rights there, that's somehow impermissible because you're going to be extending the patent term. And the court said, in fact, these are two different things. One is about a monopoly in the design. One is about the question of consumer confusion, and therefore we have two different rights. The court says Kohler's free to copy Moen's design so long as it ensures that the public is thereby not deceived or confused into believing that the copy is a Moen faucet. And in fact, the court in Walmart in 2000, right, and that's obviously the case in which the court holds that product design can't be inherently distinctive, requires proof of secondary meaning, specifically highlighted the availability of these other regimes as something that the designer could turn to until it could show acquired distinctiveness. And I'll just read the quote here. Competition is deterred not merely by successful suit, but by the plausible threat of successful suit. Given the unlikelihood of an inherently source-identifying design, the game of allowing suit based upon alleged inherent distinctiveness seems to us not worth the candle. That is especially so since the producer can ordinarily obtain protection for a design that is inherently source-identifying, if any such exists, but that does not yet have secondary meaning by securing a design patent or copyright for the design. The availability of these other protections greatly reduces any harm to the producer that might ensue from our conclusion that a product design cannot be protected without showing a secondary meaning. So it seems, at least from these opinions, that the courts are saying the availability of, and that Congress and at the federal level has established these separate regimes with separate requirements, doesn't preclude getting protection under more than one regime. And yet, right, we still have in a sort of separate line of cases that I'll talk about briefly, this sense of, well, what does it mean then to have the design patent, what we're talking about here, expire, right? If in fact there's this quid pro quo embodied in the nature of the design patent, that the grant is for a certain term of years, after which the protected material goes into the public domain, is available for copying, what does that actually mean if, in fact, there are other rights, trade dress rights, available for that same owner to assert after the design patent term is ended? And in fact, and the argument would go, and would provide the same kind of protection as the design patent would have, the protection against copying. And I think the way that the courts have answered this, at least if we read this sort of arc of the cases I'm about to describe in a particular way, is on the question of sort of remedies, right? So what remedy is attached to which of these IP rights? So many of you will be familiar with this line of cases, but I'll set them up quickly. Singer, for example, right? So the question, Singer manufacturing, they were now going back to 1896. We've got a number of sewing machines manufactured by Singer. The patent has expired. We're talking here about utility. Patent has expired. The defendant now manufactures identical machines and in fact calls them Singer machines. And the court holds that the fact that the patent has expired means that the defendant not only has the right to make the machine, but also to call it a Singer, because that's in fact the generic name at that time for the machine. But what it couldn't do in copying it was to deceive the public into thinking it was getting sewing machines made by the Singer company. And so the court said it reversed and remanded with directions to enter an injunction enjoining the defendant from using the word Singer without clearly and unmistakably stating in all advertisements that the machines are made by the defendant. So impose this affirmative obligation on the defendant, even though it was permitted to copy the subject matter of the expired patent. It imposed an affirmative obligation on the defendant to tell the public that it was the maker of these machines. And we see the same thing in the Kellogg. This is the shredded wheat case. Right now we're at 1938. Again, the patent, we have both utility patent for the way of making the shredded wheat biscuits and the design on the shape. Those have now expired. The question now is, can the defendant make the cereal in the shape of a shredded wheat biscuit and call it shredded wheat? The court says yes, but it has to use reasonable care to inform the public of the source of the product. right? And in that case, the court said, and Kellogg's has done that because of the way that the shredded wheat is sold. Most of it is sold in packaging that's clearly marked with the Kellogg name. And so the court holds that we don't need to remand for this new injunction, that in fact Kellogg is doing what it should be doing. It is both copying, as it's allowed to do, the subject matter of the expired patent, and telling consumers of that product that in fact it is Kellogg that is making that particular product. Continuing through, again, cases I'm sure you're familiar with, Sears Comco, Bonito Boats, all along the same lines, right? So Sears Comco, Bonito Boats are in part about sort of preemption issues, right? They all involve state laws that are trying to provide patent-like protection for things that would not have been protected under federal patent law. And so the courts are reaffirming there that when the patent expires, right, or in fact there's a deliberate exclusion from the federal patent law, that in fact that is open then to the public to copy, right? That's the point, that sort of quid pro quo. Once the patent expires, anyone is free to make the thing that is the subject matter of the patent. But in the Supreme Court, and this is now 1989, emphasized this in Bonito Boats, that still leaves room for state law on an unfair competition basis, not to create a statutory scheme in which somebody is prevented from copying the thing itself, from making the thing itself. That would be impermissible in light of federal patent law. But state unfair competition law is allowed to play a role if it's about the labeling that we were talking about in Singer and in Kellogg, right? About saying to that defendant, you may copy this thing so long as you make it clear to your consumers that in fact you are the defendant and not the plaintiff. The last couple of cases just to bring up in this regard, I think, are Traffics and Daystar. Traffics in 2001, Daystar in 2003. Where the language in those cases, and particularly in Daystar, I think has sometimes been read to suggest something different, especially since Daystar, if you recall, Daystar is involving copyright that has expired, fall into the public domain because of failure to renew. And then the question is, was there an obligation on Daystar's part to avoid reverse passing off? So if you're familiar with the Daystar case, this is a case in which there was a film involving Eisenhower's crusades in Europe. That series, it was a television series, fell into the public domain for failure to renew the copyright. Daystar sort of edits it a bit, repackages it, and then sells this now as a Daystar production rather than the 20th Century Fox production that the program originally was. And the question was that reverse passing off because of failure to credit 20th Century Fox? And the court there holds no, that now this is in the public domain, the right to copy, and the court says, and to copy without attribution is part of that quid pro quo. That, I think, though, even though the language there, I think, is broader, and I think, to my mind, it actually overreads the prior case law that I just described, I think we can characterize that case as different because in that case we are dealing with both a reverse passing off claim rather than a passing off claim under unfair competition, and also dealing with a case where, in that case, the court held that when we're talking about trademark law as indicating, or trademark indicating the source of the goods in that case were, the court held, the actual physical videotape that Daystar was selling in the marketplace, and in that case, Daystar was accurately informing the public that it was the source of those goods, right? And the court said trademarks don't apply to the commutative good, the film that was actually included on that videotape. So that case to me is a little bit more of I think, an outlier in terms of the arc that I'm describing here, in that we have both a statutory interpretation that says that Daystar was in fact labeling accurately, and a reverse passing off case rather than a passing off case. So all of those cases, I think, if we read them in sort of a historical line, tell us that when we're dealing with the overlap here of rights, right, that the courts have been consistent to tried to preserve each doctrine here within its particular sphere, right? So that when, for example, the design patent term has expired, right, and then the quid pro quo embodied in that is that therefore that becomes available for others to copy. That when we look at what the overlap of trademark law, of unfair competition law should be there, It's not about preventing the copying as such, right? Because then that would create the conflict that we've been talking about. But it doesn't also mean that there be an obligation on the part of the defendant to engage in some sort of affirmative labeling or description or advertising to deal with trademark laws' core goal, which is to ensure that consumers know from whom they're getting the product, right? So that might involve an obligation to include some additional mark or some additional logo or some additional advertising. So I think when we read those cases, that's where we sort of end up at the end of the day. So I'll turn over to Mark now to talk a little bit about sort of how the functionality and other doctrines have worked to channel, and then we can move on to a discussion about whether that's the right answer.
Thanks. Okay, so I'm going to try to be a little bit brief here, and what I'm going to try to do is kind of sketch out a landscape of what I call channeling doctrines, and what I mean by that are doctrines that have been developed, I think, primarily by courts, sometimes have found themselves then incorporated into statutes, that try to, at an individual case level, sort out whether there's a conflict between one or more of the rights regimes that requires one to give way to the other. And so I think it's worth saying at the beginning, just to kind of frame this, that the need for these doctrines is a function of the expansion of the subject matter of each of the rights regimes. So that at the beginning of our design patent experience in the United States, copyright doesn't reach most of what design patent is intended to cover, and really neither does unfair competition. There's a pretty stable line of cases that says unpatented designs are free for copying, subject to the labeling requirement Laura was talking about before. And so a significant part of the explanation of the beginning of the system is a felt need for some form of protection that was falling through the gaps of the other sort of systems, right? So of course what's happened over the last 150 years is that it's no longer the case that copyright doesn't reach most of those things, and it's certainly no longer the case that trade dress doesn't reach most of those things. And so that's kind of heightened the need for, or courts felt need to see if there are some ways to police that, now that we have multiple rights regimes touching the same thing. So just to, as a kind of a landscape thing, I think you see this kind of across many, but certainly not all, of the places this regimes intersect. So the last panel was talking a little bit about ornamentality and functionality, functionality interpretation of ornamentality as a way to police the boundary between design patent and utility patent. It's probably worth saying there that it's interesting that the policing is really only unidirectional there. The concern is that people will evade the requirements of the utility patent statute by using the design patent as a sort of weaker route. Doesn't seem to be any concern, I think for understandable reasons, that the opposite will happen, right? That people will use utility patent to cover things that are actually really designs. If you can claim them appropriately, there isn't any real doctrine that would prevent you from doing that. Obviously, I think the explanation for that is that people don't think anyone would rationally choose a shorter system and a weaker protection for things that they could otherwise bring in the utility system. But I think it's just worth mentioning that at least that dividing line is usually seen as needing policing in only one of the directions. You can see this a little bit between utility patent and copyright and the useful article doctrine. You see it most prominently in the line of cases Laura was talking about between patent and trademark. And there, I think the dimensions of that policing have changed quite a bit over time, and now I think overwhelmingly tend to focus on the division between trademark and utility patent, and not so much design patent, which I'll come back to in a minute. I think I just want to say, sort of characterizing all of those, one thing that's interesting is that if you look at the sort of arcs in the history of all of them, they all perpetually struggle with largely the same problem, and that is that design is by its nature dual. It has ornamental or aesthetic elements to it, and it also has functional elements to it, and all of them try to draw a binary distinction about things for which there is no binary distinction to be drawn. And so really what they are ultimately doing is deciding which of those kinds of things are they going to preference. Are they going to say, is it more important that we give weight to or give recognition to the functional aspects here over the aesthetic or the source designating, or vice versa? And I think that's where you sometimes see the gaps between the doctrines. Right, so I don't mean to suggest when I give this landscape, these doctrines are not applied with equal rigor. I think, as I'll say in a minute, I think it's very clear to me that functionality in the trade dress setting is a much more serious bar post-traffics than functionality is in the design patent setting. I think there's one case in which, at least at the validity stage, it's being applied. And that the rigor of those doctrines has evolved over time, that we see time periods in which courts are sort of more interested in doing that policing and ones when they're less. And there's also some kinds of interactions that seem to be missing, so I think it's kind of interesting that there's, though there's the useful article doctrine to kind of police the boundary between copyright and utility patent, there doesn't seem to be much concern about the overlap between copyright and design patent. There doesn't seem to be any policing of that boundary that really goes on. For me, a point of interest is that there is, I think, much less interest in policing the trademark design patent conflict than there is between the trademark utility patent conflict. I think that's actually a mistake, but I think it's descriptively true. So I want to just focus on one of those interactions, just to make one point about it that gets treated a little too dismissively, I think, and that is the issue of the role of expired or invalid design patents on trademark functionality. So as you might know, courts are fond of saying something along the lines of the existence of a design patent or an expired design patent is actually strong evidence of non-functionality, which a conclusion that they reach because they say, well, if what we're trying to assess on the trademark side is functionality, and if a requirement of the issuance of the design patent is that it be non-functional, well, look, those must be the opposites of each other because they're using the same word in both places, right? So where in the design patent context, right, where you have the problem, I think, is that this gap is that in the design patent context, functionality means something very low, right, as a threshold. So you got to be, the overall design has to be dictated by function, and so where design is mixed, as I think I posited earlier that it always is, in that some of it is determined by function, but not all of it. It's not entirely constrained by function. There are also aesthetic elements. In those cases, design patent says we're not going to throw them out of the design patent system. We're going to let them stay in. We're going to give preference to the ornamental features unless the balance is so high in favor of the functional elements that we're willing to throw it out, which I think, as we heard, virtually never happens. So trademark functionality, I think, at least post-traffics, predominantly does exactly the opposite of that. Where configuration is a mix, meaning some of the features do have some function, but there are other ways of doing it, and those features have some source designating function. I think post-traffics, this is certainly the rule, at least outside the Federal Circuit, which insists on doing its own thing, surprisingly. The trademark law overwhelmingly says, look, if it has function, I think you see the Seventh Circuit say this in the J. Franco case the most strikingly, if there's even a drop of function in there, it's out of trademark. So I think the interesting thing there is to see that there's a big gap then between the two of them, that actually what trademark law does is where you have mix of design features that are both functional, both useful and are also aesthetic, is that trademark law is very much more inclined to kick them out than is design patent. And that means that there's kind of an undistributed middle there. There's a big number of cases that design patent would not say the design is functional, but that trademark law would say is functional, right? So, and I think the takeaway from that is to say that the statement or the conclusion that, hey, if there's a design patent, that's evidence of non-functionality has just got to be wrong as a general rule if you're trying to apply that in a trademark context, because even aside from the question of whether we ought to care more about a conflict with design patent itself, you can't assume that a design patent means that the thing is not mechanically functional in a trademark sense. There's actually a whole bunch of things that are mechanical, are mechanically functional in a trademark sense, but that the finding of non-functionality in the design patent system gives you no insight into. And then I just say that my plug here at the end is to say that I think we should also actually also think much more about the conflict between design patent and trademark, even if we are talking about something that would have been sort of design patent subject matter and also wouldn't have been mechanically functional under the trademark setting. I think it's worth mentioning here that this is actually what the Comco case is. The reason that Supreme Court takes Sears and Comco as a pair is not to just sort of like reiterate again what they said in Sears. It's because Sears is a utility patent conflict case and Comco is a design patent conflict case, and it's notable that the court treats them exactly the same. And the court says exactly the same policy things animated. I think that's gotten lost over time because people dismiss those cases too easily as preemption cases, and given the rise of 43A. But I think the policy question that the Supreme Court faced there is actually exactly the same, and that's kind of gotten washed out over time. So it could be the case that we could think about aesthetic functionality doing that role. Aesthetic functionality is obviously much more controversial in trademark doctrine, but you could at least conceive of using aesthetic functionality as kind of a mirror image or as a cousin of mechanical functionality for doing the policing of the trademark design patent interface the same way mechanical functionality polices with utility patent. I'll stop there.
Thank you, Mark. Well, with that state of the law outlined, I think it might be a good segue into sort of how either in-house attorneys or their partners outside can really think about, within this state of the law, how can we be maximizing the protection for our business partners or clients, and what pitfalls should we be aware of when looking to use different types of IP protection?
Thank you. I know, and as I explained some of these strategies, I mean, they're obviously in the context of everything we've already spoken about, but I think the easiest way to think about the law and these overlapping IP rights are as kids playing in a sandbox. And I think that design patents and copyrights and trademarks all pretty much play well together. There's you know, we have various rare exceptions where there is an issue, but those three play pretty well together. The problem is when the bully, the utility patent, kind of comes in with the design patent or the copyright or the trademark, where things could heat up a little bit. So from a top-down position, I guess, you know, ideally you want to analyze any particular product or project on a case-by-case basis to see which of these 4 rights that you potentially can get rights in. I mean, you don't want to overlook procurement of rights in an area that you can get it and might end up being valuable. I think the big trick comes down, to, you know, when it comes to, do you also want to get utility patent rights? Because now, based on whether you get a utility patent right, what you describe, what you claim, all could have an impact on the other rights and how you do it in the application. So, you know, against that backdrop, if you're doing a utility patent application, so I guess taking a step back, one great example that I thought of here that might be a good baseline for some aspects is the automobile body, you know, the body of an automobile, a really new design, very aggressive, doesn't look like anything else that's been done before. So, you know, under that standpoint, there may be some really neat things about it that make it aerodynamically superior to other sedans or whatever. So you may have the ability to protect it with a utility patent as well as with the design patent, and eventually over time, if it gets acquired distinctiveness, you can probably protect it with a trademark on their product configuration mark as well. Copyrights may be difficult to get unless there's a lot of fanciful aspects associated with that. So against that backdrop, you know, the other thing too is, even though you may want to get a utility patent application, you may have a marketing department that wants to say how great and how aerodynamic that is. And if you know, you're going to want to make sure that your marketing department gets in sync with whatever strategy you're going to do, because it doesn't make a lot of benefit to not go with a utility patent because you want to preserve your rights in the other fields, and then your marketing department turns around and touts the functionality of it anyway. So that's one aspect. But then if you do make a decision that you want to go ahead with the utility patent application, and this is where I probably prefer not talk about the car design, but if you're going to go that aspect, the first thing is don't show your commercial design. That's the first thing. Hopefully there's no reason to show it. I mean, the client's going to give that to you, and that's going to be the basis for what inspires you to write your disclosure, what inspires you to write your claims, and how to maximize protection from a utility patent standpoint. But odds are you probably don't have to show that commercial embodiment, what they're bringing to market. You can either usually show it schematically, or alternatively you could show designs that are not going to be commercialized. There might be some reasons where you have to disclose it. It could be that you're either you're getting the disclosure the night before a trade show, and you want to make sure you get it in and you don't lose rights in it. And another aspect may be that you may believe there's some best mode requirement that you do want to include that. So if you're going to do that, you should also make it a point of showing alternative designs and describing alternative designs and really pushing that through, because that's going to support non-functionality from a design patent standpoint. And if you do it at that point in time, it's going to be much better than getting an expert to draw it up in a design patent litigation, because I think juries are inherently suspect of an expert creating things for litigation. But if you file the patent application and there's 2 or 3 different alternative embodiments there, and the language is that it's not dictated by function, and that there's all these different things that perform equally as well, that it's going to be credible, and it's going to be honest, and it's going to be contemporary in time.
Yeah, thank you. Is there anything, if you're on the other side, say you're, as I think Laura put it at the beginning, on the other side of the V, if you're the defendant or a potential defendant, what should you be looking at or thinking about when you see, for example, that a third party had a design patent, but it's now expired?
Right. I would counsel the client that I would not be relying on any right to copy. I mean, if you want to have clearance, I would not be relying on that at all. I mean, it may turn out that it works out, and I think that the strength and what the court was trying to achieve in the shredded wheat case, as well as in the Singer case, was they basically said that design, that mark, was so intertwined with the use of the invention that we're not going to let you impermissibly extend extend the essence of the invention. So, I mean, I think in the shredded wheat case, the machines were made to only make biscuits of that configuration. They couldn't make it in a different configuration. So, basically, if you were trying to use that machine, it would make that product. And so, to turn around and say there's trade dress rights with the product, it means you couldn't use the patented machine. And then I think that there was, let's see what else. So I think, but in other areas, like they had that Thomas Betts case. It was a cable tie fastener, and the top of it was oval shaped, and even though that oval shape was put in the utility patent application, they were able to see through that it wasn't the essence of the utility patent right, and they were able to say that that's okay. So that's the first thing, is I wouldn't rely on a right to copy. The second thing is...
Sorry, can I just ask a question real quick to clarify? I'm sorry. So when you say you wouldn't rely on right to copy because you think there are trade dress rights that same owner is going to be asserting? What is it? Why when you say you're not relying on right? So I mean, under the hypothetical that we've got a situation that there's a design patent right that's expired. I don't know about the utility patent right that's expired, but if, assuming that they've dotted their I's and crossed their T's and have gotten a registered trademark, hypothetically, right? So they've got trade dress rights on it, and they've got an expired design patent. I wouldn't say, oh, the design patent's expired, feel free to copy. I would not advise the client that way. I would do the due diligence and make sure that there's some way that we don't infringe on the trademark side, and make sure that either there's no likelihood of confusion, or that they properly mark to make sure that there's no confusion, or try to look to see if there's some defect on it. But I wouldn't tell a client that, oh, the design patent's expired, don't worry about any trademark considerations, go ahead and copy. Sorry, go ahead.
No.
Part two.
And then, obviously, I think you have to clear each right separately. I wouldn't I'd double check to see. I mean, obviously, copyrights. You'd have to see if it is copyrightable. Not a lot of these products are not copyrightable, but if it fits the like the Mazer v. Stein stuff, right? I mean, that's a lamp with a sculpture on it. You just can't copy the sculpture, even if a design patent is on it. So make sure you're clear on copyrights, make sure you're clear on utility patents, make sure you're clear on design patents, and make sure you're clear on trademark. I mean, I think you really have to consider all of them.
Yeah, so that sort of takes me to the next question. As you're advising businesses with all these overlapping rights, I mean, on the trademark side, there's some pretty straightforward ways of conducting a clearance search, but with the overlapping rights, if you're dealing with the design, how would you advise a client to go about clearing a certain design that they can feel comfortable using, keeping in mind that nobody has a sort of unending budget?
Right. Well, so if I understand your question, so is this assuming there's an expired design patent or not?
You don't know. You have a product.
I mean, normally if it's a product, I mean, I think people are not going to, if it's a product configuration, they're not going to be entitled to trademark rights on it unless they have acquired distinctiveness, which means that they've been in the marketplace. So the first thing I would look to see is, I mean, the right of choice on generally speaking on product configurations is design patents. So I would look at that first and see if they have that. And you know, and then if in fact they're clear on that and there's no design patent or they're, you know, then the next question is how long has the product been in the market? If the product's only been in the market for a year, then likely the fact that you couldn't find a design patent doesn't mean anything. It could easily still be pending. So there's always a danger to copy a design if something could still be pending on that. And then after it gets there, you know, and you've cleared on the design side, you can look to see whether or not it can qualify as a copyright. Then now we're jumping to the trademark side. If it's a product configuration, I mean, first of all, you always try to advise your clients not to copy at all. It's easy enough to hire good designers. There's a lot of great designers that are coming out of school. They can do it. They can create something unique and help brand your company out. And you shouldn't be in an area where you're trying to simulate anything else. I mean, but against that backdrop, if you have that, on the trademark side, you need to take appropriate steps to make sure that there's no marketplace confusion.
The copyright part.
Well, I mean, I think what I do, generally speaking, well, I mean, it depends on a case-by-case basis. I mean, a lot of people will do that in-house. But, I mean, the first thing is I look to see if, I mean, really, I just do an analysis of the product to see whether or not it is copyrightable.
Assume it is.
Well, then basically, if it is copyrightable, like a Maser v. Stein sculpture on that, and, you know, the fact that there's no registered copyright doesn't mean anything. Right? I mean, if they have a registered copyright, they may be entitled to statutory damages, but whether or not it's registered or not is irrelevant. I mean, if it's copyrightable material, you say don't copy it. That's the essence of the clearance is you look to see whether it's copyrightable.
Can I just add one thing? So aside from the fact that, like, I think it's kind of an indictment. It's an indictment of the system if the advice everyone is giving is even if things have expired, don't count on a right to copy. That strikes me as an indictment of the system. But I think it's also probably important to say when you say to your clients, don't copy, that there's a lot of fuzziness about what exactly that means, not to copy, right? Because at least if you're thinking of this from a trademark perspective, the fact that you don't copy exactly or you make some sort of differences is not going to be enough for you to escape liability if it's still within the likelihood of confusion range. So it's more than just don't copy. It's get far enough away that you're outside the scope of all these rights. And of course, that just then begs the question of what's the scope of all the rights. And the broader they get, now the further away we're getting from a copying regime and the more we're getting away to saying, actually, this is just product differentiation, right? Just get further away.
I mean, would you say, I mean, if we could go back in time, and I guess, again, this question depends on which side of the V you're on, but go back in time and say, you know what, we should never have given trade dress protection to product configuration, right? Because that's the problem. That's what's causing all of this problem here. I mean, would you have, as a representing clients, would you say, yeah, actually, that would make my life a lot easier?
Well, I mean, I think it is important under certain circumstances. I mean, I don't think for every particular case it should be available, but there's no doubt about it that product configuration marks to some extent should be permissible. I mean, it might make my life easier, and it might, but the fact is that I think that if somebody creates something, I mean, the great example is an oval shape on the end of a cable tie, where the oval shape has nothing to do with how it locks. And if people could recognize that that shape at the end is, oh, that I know what company that oval shape is. Company A makes that oval shape, or it's a pentagonal or whatever it is. Oh, I know what company makes it because of that aesthetic feature on there. I mean, it's part of the branding. That's the way business is done now, and I think that the law should find a place for that kind of protection. and within limits, but it needs to prevent a likelihood of confusion in the marketplace and permit branding at the same time.
And as a trademark owner, is there any situation in which you say you do have the ability under the current law to claim more than one form of protection? Are there any situations or reasons why you wouldn't do that?
Well, I mean, I think, going back earlier, I mean, I think under utility patents, I think that if the utilitarian benefit is marginal, and I think that you probably won't be able to get a utility patent on it, well, then it's not worth the risk of filing a utility patent in a way that puts the presumption against you, as the court said in Traffics, right? I mean, that's where it is. If you show your trademark feature in a utility patent, it's going to put a heavy burden for you to overcome to show that the mark's not functional.
Yeah. Good. Well, getting back to the state of the law, I think you all did a great job of explaining where we are now. Do you anticipate any changes? Do you see any trends, any sea changes coming up?
So, I mean, my view is that the design patent trademark interface is much more alive now. I mean, so Apple, Samsung changed everything, right? And I think, so we're going to see that conflict much more. I mean, I think courts for the last decade or so have been thinking about functionality almost entirely in sort of the traffic's utility patent thing. And so I was listening, Rob, when you were saying something about like the essence of the utility patent. There's still, even post-traffics, remains a line of cases where courts really try to dig into the patent document to figure out whether what you're copying is actually part of the essence or the sort of the thing that's being. I think Traffics actually suggests that's the wrong approach, but it persists because they're really thinking about functionality in those terms. I think that we're starting to see a lot more cases where that's not exactly what's going on. It's really much more of a sort of an aesthetic functionality design interface. So I think that, from my perspective, that's where there's going to be a lot more action.
Mm-hmm.
State of the U.S. well known.
Okay,
I'll wait to the China one. My skills.
Oh, by the way, thank you for mentioning Mason Sonia. I meant to mention it and forgot, of course. Important case in that regard. And I don't know whether this is sort of predictive or just sort of optimistic on my part. I mean, I think one of the things that you've seen a couple of courts starting to do. I mean, there was sort of this general aversion, I think, at least. If you go back a few years to things like disclaimers, things like corrective advertising, right? The idea that, well, nobody pays attention to them, they in fact sometimes reinforce the confusion that you were trying to eliminate in the first place. And I think using those kinds of things as and Mark has written about this in the past. It used to be a fairly, I mean, as we saw, in the Kellogg-Singer cases, right? That was the remedy, right? Yes, go ahead and copy, so long as you include affirmatively, right? You had an affirmative obligation to make sure that the consumer understands from whom they're getting this product, right? And I think that's kind of gone away, and we've seen a little bit, I think, in at least a couple of cases, maybe courts being a little bit more willing to look to that as a way of kind of helping to deal with these overlapping rights a little bit. So, like I said, I don't know if it's predictive or just hopeful on my part, but to my mind, if courts were more willing to say, okay, so here are the rights that we get sort of under design patent, that's what that allows you to do, here's what happens when that expires. But we also have this sort of unfair competition-based thing that we also need to worry about, where we have consumers' interest at issue over here in terms of figuring out from whom they're getting the product. And in that case, we would have this particular remedy that would deal with that particular harm. That, I think, would help things more. Mm-hmm. So if we could encourage courts to do that a little bit more, I think at least that would advance things a little bit.
Mm-hmm.
There's one there.
So, I was just, with respect to the dichotomy between design patents and trade dress product configuration, is that from a practical standpoint, not every product configuration, no matter how long it's sold or how much it's advertised, will rise to that level. I mean, you get a presumption after, 5 years or something? But not everything will rise to that. On the other hand, the other problem that you have with product configuration, trade dresses, if it gets too famous, then there's no confusion. So I want to know, when you reach that point of too famous, what the panel's thoughts would be on how you deal with that if it's in a trademark sense.
It's interesting. You know, I don't.
Don't say dilution.
No. Well, I mean, I mean, you know, I mean that is interesting. I mean, I don't know if it's too famous that inherently means that you can't have a likelihood of confusion. I don't know if that's the case. I mean, I think if a third party made something that looked like the famous one and they didn't adequately identify the source and there was a likelihood of confusion as to whether that was, you know, made by that same company, I still think that you have a valid trademark claim. One of the things I wanted to comment on what Mark said on there, I do think that there's going to be some fallout of perceptions from that Apple-Samsung case, and I think that as different parties are procuring both design patent and trademark rights, it does kind of create an interesting issue for judges, right? So, and the litigants. I mean, one of the interesting things there is, I think one of the things that helped Apple reach the decision with the jury was there was that kind of smoking gun letter from Samsung's president about, you know, the icons and the appearance of the icons and how come our icons don't look as good as Apple's icons, and just getting that in front of the jury, I think, helped set the tone of the case separate and apart from the merits, but it was so intertwined that it helped Apple's case immensely. But I think because they were able to assert design patent and trademark rights in both those cases, they were able to get that in the case. I think if it was just a pure design patent case, I think an argument could be made and that memo might not have been able to make it in, or there could have been a motion in limine to get that out. But because Apple had design patent and trademark rights, and they could bring them both in, I think that helped their litigation position. So I think you're going to start to see more practitioners, encouraging the companies to get both rights. And if the stars align, where you can enforce them both, it may create some strategic options from an enforcement standpoint.
I think there's no doubt that the practitioners are going to start advising to get I gave a talk at the Cleveland IP Association. I was talking to this in-house lawyer, and I think he thought we were on the same page about this when he said this to me. But he said, I love design patents because I just go get a design patent, I have 14 years, and then voila, I've got secondary meaning. That's fantastic, right? To me, I was horrified. That was exactly the point, right? Is it so? And I think actually
that's what the court said in Walmart. The court said that, right?
So
like, that was the point.
This is actually, I think, why Walmart created a potential problem was that I think Walmart's the holding in Walmart that's saying, like, you can't protect this until you get secondary meaning, and then the reference to design patent, I think actually is predicated on them thinking you can't get both of them. But the fact that you could get both of them actually makes the fact that this all turns to secondary meaning actually much more of a pressure point and much more problematic. And especially, as Rob says, is that sometimes you're kind of in the dark about the design patent thing because it could still be pending, it could still be out there. And meanwhile, the clock is running and secondary meaning is adding up, right? While you still have to stay away from the design patent thing. So there's a lot of, to me, that sounds like a real problem.
So on that, go ahead.
Yeah, I have a hypothetical. I want to change up the facts of traffic just a little bit.
Is this a current case you're working on?
Yeah, traffic.
No, you're hypothetical.
In 2000.
The hypothetical that you're going to introduce.
No. I'm just changing those facts.
Yeah.
So,
because I see you're recording this. I just want to make. I just want to make sure that you turn your recorder off because I can see you trying to throw this in.
So in traffics, there was an expired utility bill. And the issue was presented at some time during the litigation to all the courts involved, including the Supreme Court, is what is the effect of an expired utility patent on the potential for claiming trade dress rights in essentially the same subject matter covered by the claims. And although the Supreme Court talked in terms of an expired utility patent and all that stuff, they actually dodged that constitutional issue completely by saying that the trade dress was functional. And they used the utility patent, as you're aware, as a functionality. So my question is this. Suppose the patent in that case was a design patent that covered exactly the same configuration that was used by the defendant. And Therefore, the functionality defense, if you will, is not available to the Supreme Court to dodge the issue of what happens to the subject matter of an expired design patent, the exact same subject matter that they were now asserting trade dress in. What would be your answer to that hypothetical?
I would really like to see that case, because I would really like to write an amicus brief in it, because I think I could tell them. I mean, so I think this is, if we were talking about this 30 years ago, I would have said, on the heels of Cirrus Comco, there's no doubt in my mind the court would have said the same thing about an expired design patent that it said about the expired utility patent. But I don't think you can say that now, and I think that because the court wasn't focused on it in Traffics, it said some things in ways that kind of indicated they were thinking differently about design patents, and particularly the way it talked about aesthetic functionality sets up a very different kind of framework, thinking about it in terms of competitive need and availability of alternatives, which it seems to, I think, very significantly downplay in the mechanical context. So I would like to see that issue presented to them squarely so that they can have to face that conflict. I think because they weren't focused on it, they said things that could be construed as sort of dismissive of that conflict, but I'm not sure if squarely presented to them they would say that.
Yeah, the other interesting thing about that hypothetical, I mean, again, we're separating out sort of maybe what some of us should think the answer would be and what predicting, what it might be. There are a bunch of things that would, I think, make this not quite on all fours with, as you're suggesting, with the decision in the actual case. And you're absolutely right that they particularly excluded the constitutional question. Right at the very end of the case, they say we decline to address the constitutional, the quid pro quo issue that was raised by amicus briefs in this case. And part of the interesting thing is to think about whether that quid pro quo argument actually has the same force in the court's view for design patents as it does for utility. Because part of the quid pro quo is, in order to get you to disclose the invention to the public, we will give you this limited monopoly, right, for a certain term. And the point of this, and the court, if we're trying to do prediction here, I mean, if we look at the court's opinion in Eldred, right, where it said, we don't even think this quid pro quo has as much force in copyright as, whenever we've talked about it, we've talked about it in patent, because the point of the quid pro quo is the disclosure, right? And you don't need that in copyright. You're not getting disclosure, right? It just, it happens because if the work is eventually published. And the same thing, I think, in design patent, right? I mean, the point of it is not sort of disclosure because the design is apparent, right? You don't need the disclosure of how the thing is done as you have to do in utility. So one question might be, would the court see the quid pro quo argument, which is animating this discussion, or this interest, as having the same force in design patent as it would in utility? On the flip side, I mean, I wonder if you had the same facts as in Traffics, but just changed it to a design patent, you actually might not end up with the same result, in part because of the particular circumstances of this case. And by that I mean that I think the court definitely saw MDI as doing an end run, right? That they were trying to get under trade dress what they couldn't get under patent, right? And it was just the way in which the court came up. And you see this, in fact, in the very first sort of paragraph of the oral argument on Traffic's behalf for the court, who was actually by John Roberts, right, as he was representing Traffic's. And he framed this as, MDI's patents have expired. I'll just read it to you. I actually have it here. MDI's patents expired as under the Constitution, all patents eventually must. And then sometime thereafter, Traffic's, the petitioner, copied MDI's stand, added some improvements of its own, and marketed a competing version. No longer armed with its patents, MDI tried a new tack to exclude competition. It claimed that the configuration of its stand, the same dual spring design that it had touted as patent protected during the term of the patent, was now protected as trade dress, right? So the whole thing was framed as we've got this bad actor who's trying to do an end run here, trying to get what he couldn't. Same thing actually was happening, I think, in Daystar too, right? You had a bad actor, lost the copyright, couldn't get it under copyright, trying to get it under unfair competition law. So in that realm, I think we might see the same result if, in fact, it was the same facts where we had this perception of a bad actor. And then I guess that's your discussion about, are you in fact a bad actor, right? If that's what you're doing.
Yeah. The one, with your example, I mean, I think it's really going to turn on. If you look at all the old cases, they don't really focus on whether something's expired or not expired. They always go, all the Supreme Court cases, they always go back to the word public domain, the phrase public domain. So whether or not you get a design patent and it expires or you never get a design patent, or shouldn't matter. It's either in the public domain or not in the public domain. So if you're taking that as your essence, then the fact of the matter is, if you're going to say that there's not, that there's not a design, there's no existing design patent rights, can you get trade dress rights? The question just goes to, should we allow trade dress rights on product configuration? And the answer.
But the quid pro quo.
No, that's not what it says. If you go back and you look at let's see, I forget whether it was Singer or shredded wheat, but it was the patent never expired. It was invalidated short of reaching the end. One of the old cases.
Shredded wheat.
Well, there was one of the it may have been the.
Shredded wheat was the design that had been found invalid, and the utility for the machine.
I think it's right. I mean, I think there's an often overlooked passage. There's a part of traffics where the court explicitly says, all of what we're saying here would be true even if there was no patent at all.
Yeah, that's right.
Because this is the kind of stuff that patent law treats. So I think actually the expired utility patent just makes it a more pointed question.
Yeah.
Because then the quid pro quo thing is there, and it's very clear that it was something patent law would reach because it was actually subject to a patent. But I think you're right that the question is not specifically that. It's about, is this the kind of stuff patent law deals with?
That's right. And so I think whether or not that case wins or not is whether or not Congress and has basically said that it's okay to have product configuration rights, whether all that is good. And I think the answer to that is yes. I think that an expired design patent won't inherently kill a product configuration mark, assuming that everything else is fine.
Chris had a question up there.
Yeah, it seems like the rationale we've been hearing for why there should be prohibition post an expiration of intellectual property, be it copyright or design patent, design or utility, is this idea of the right to copy document that I'm hearing up here. And the cases that seem to be being referenced up here, the Singer, Kellogg, or Scott Paper, those are all pre-1946, pre-Lanham Act. So this intervening event of the Lanham Act, I suppose, could be viewed as saying, well, we understand those case law, but we're going to allow these particular rights with respect to the trademark and trade dress rights to attach later on. And I would like to ask the panel, through that lens, it's just hypothetical if you had, say, the old Tin Lizzy, where you have a body carriage, you have rotatable wheels, you have an engine, and controlling means. Does that, what exactly is dedicated to the public domain? Because I hear some talk on panel about claims, what falls within the scope of the claims, because that really would be what might be limited monopoly, which is expired. But those cases, Supreme Court cases, go much beyond that. They say anything that's disclosed in the patent itself. And so I can imagine within the confines of that patent claim, that independent patent claim, myriad car designs. For the next 100 years, probably 10,000 car designs, which is pretty within the scope of that particular. So I guess my question is, if there is a right to copy doctrine, what exactly is off limits? Doesn't matter if it's the same party. Professor McKenna was suggesting that something smells wrong when it's the same party about the expired patent getting the secondary meaning during the course of the patent, and then asserting that later on. What if it's a totally different party? And can that stuff in the public domain be appropriate? The color orange, a company that's in the public domain, but a company can certainly appropriate that so long as they meet the requirements.
I personally think that that's all subsumed in the functionality doctrine and part of the analysis. That makes the most sense to me. That you don't analyze this on a, okay, we're going to slice and dice this right to copy up and figure out where it is. I think we say, okay, we have a functionality issue. It's relating to a utility patent, and we're now determining whether trade dress rights are applicable on this. And well, that's the question. I mean, when it comes down to, if what you're saying now is like you're trying to get trade dress rights on a utility patent, right? So I think you were kind of looking at it. Okay, we're looking at the utility patent. It's expired. Let's formulate our right to copy. And I think it's the other way around. I think you look at your trade dress right and you say, okay, is this functional? And to determine whether it's functional, we're going to look at the traffic factors. We're going to see what was disclosed. We're going to see what was claimed, and we're going to see whether or not that should be barred protection.
Well, that's not a right to copy.
Well, I understand, but I think that's the appropriate law.
Well, that's what traffic said.
Right. So, I was just going to say, I think there are what I think of as right to copy cases, they're clearly post-date the Lanham Act, Sears and Comco, for example. But I think it's also important to say that the Lanham Act, when it was originally passed, did not contemplate product configuration trademarks. Courts and the PTO did that. And then it was later put into the Lanham Act and codified. So I don't think you can say that the intervening Lanham Act did that. That was clearly done by courts, even though it was, I think, pretty clear from the legislative history that Congress was not intending to do that in the Act. The problem with the Sears and Comco case, in terms of just fast-forwarding them, is that they're preemption cases, but that's because of the intervening. So Sears and Comco are different than Kellogg and Singer, because Kellogg and Singer are pre-Erie, and pre-Erie they're general unfair competition cases, and post-Erie they can't be because there is no such thing, so they're state cases. But that means that then when 43A starts being applied more broadly, which is right about the time Sears and Comco are decided, now all of a sudden it's not a preemption question now, because now it's federal instead of federal-state. My own view is we'd be better off going back to a Sears-Comco view and just saying if it's a design, it's not protectable by trademark, you got to go get a utility or design patent. I think part of what you're identifying is exactly why, is that the costs of this system that we have now are enormously high. You've got to first figure out if something has secondary meaning. You first got to figure out if it's product configuration, right, which the Supreme Court basically told us there is product configuration, there's product design, and then there's product packaging, and then there's maybe this other thing too. We're not going to tell you what's what. You just, like, sometimes a Coke bottle will be in each category. You figure it out, right? And then you got to figure out if it's functional, and if it's functional, sometimes that has to do with the scope of the disclosure. So I think the number of instances in which a trade dress actually makes it through all the hurdles, right? It actually has secondary meaning. It's actually non-functional, and therefore legitimately protected is actually a very small slice. And in order to go after that very small slice of the world, we've been interjected a legal system with enormous cost. And so, to me, we'd be better off just going back and saying no.
So I'm going to ask that we move on to beyond the U.S. and bring Tom into the discussion. Would love to hear your thoughts on. Still looking for directions. To hear your ideas on any major trends happening outside the U.S. on overlapping rights, and any advice or best practices for U.S. practitioners in maximizing the way they use those overlapping rights.
Thank you. Yeah, I was brought in to derail a really good conversation. So I'll do my best. My daughter, actually, high school age daughter, she's on spring break, is actually with me this week. Well, she's somewhere on campus. And I'm trying to encourage her to show up to these things. This is good, meeting people, learning something valuable. And she said, well, Dad, what are you going to talk about? And I said, knowing where this is going, I said, well, I'm going to talk about a parallel universe. And I said, perhaps even an alternate universe. Well, she's pretty bright. She saw through it. After the distinct roll of the eyes, she says, you're going to talk about patents, aren't you? I said, hey. So you can see she's not in the audience, so she's somewhere on campus enjoying herself doing anything other than being there. We learned in law school in Patent 101, trademark copyright, that here's the U.S. practice. And I can't really say that that's helped us along the way. I teach a couple of classes as an adjunct, and we just began teaching a treaties class this year, intellectual property treaties class. Nothing but treaties. And that's been fun for me, because it's the first time I've had a chance. We talk about treaties in classes, but we don't talk about treaties. We talk about Article 1 or The Hague and the components of it. But we never give it the due respect, because we're hitting it and moving on. We're going at a high rate of speed. And so I really had a chance to talk with my students, and I think I brought a certain amount of awareness to them that there's a lot going on out there that we're not really fully understanding or allowing ourselves to understand, you see. Because we presume, well, in the patent kingdom we have in the U.S., we've got the utility patent, called in many other countries in the world, particularly China, a utility model patent. It's not the same thing, but that's where utility gets confusing. China calls it an invention patent. So I've begun calling it an invention patent just because I'm trying to differentiate. And I talk so much about utility model patent in China, I tend to overlap myself, so I have to make sure I differentiate. But we're taught there are two. We're taught in the copyright world that you can't get anything that's industrial art. You can't get that protected in the U.S. And then we let it go. And so we try to extend our clients' rights. And I don't mean just taking a design right and filing it in Europe. And when we talk about extending their rights, we limit ourselves, thinking, well, we could get a design right, but it can't be functional, because the U.S. doesn't permit much of that. We talk about, well, we can get copyright, but it's limited to fine art, because the U.S. doesn't permit anything beyond that. And it's a disservice to our IP community. It's a disservice to my clients if I don't bring this knowledge to them and discuss these options they've got. We've got a couple of terrific clients that have given me a lot of latitude in terms of exploring possibilities out there. Plus, it's my interest. Back when I was working at the Chinese Patent Office in '97 as a foreign advisor, training some of their examiners, I realized how far we had to go, how far they had to go. When I had one of the patent examiners, mechanical engineer, a bright guy, walk up to me and ask me if, Mr. Moga, I don't think they knew I had a first name. Mr. Moga, would it be possible for us to get a copyright? This is when the euros had just started being accepted. A copyright registration on the euro, and then we could charge a royalty on every one of them that was issued. And I'm sure that examiner today is probably an SPE or something, a high-ranking examiner, and that kind of thing worries me. But it shows that there's a gap in understanding. I think one of the great challenges we have in this room, and as we leave this room, is to try and extend that, to think not just about the design patent in the section of room 290 here, yeah, but to extend beyond that and look into possibilities. Let's take a look at design patents as you go overseas, you go abroad, and look at some of the challenges. And I tend to default to China just because I've spent, as my family will say, too much time there. But you take your design patent to China, and you've got an amazing reception for design patent, because right now, last year in China, there were 1.2 million patent applications filed. Million. And it's almost equally distributed between design, utility model, and invention patent, our utility patent. And you're in good company. About 400,000 patent issued. The Chinese Patent Office, well, actually the government sitting in Beijing, has said that by the year 2015, we insist that the Chinese file, this is not foreign applicants, the Chinese file 2 million patent applications by the year 2015. Now, this is a staggering number, and this is the subject for a whole day of debate, discussion. But the reason I mention that is because right now we're looking at around 400,000 design patents being issued in China a year, over that number, not one of which is examined. These are applications that are received, and as long as the I's are dotted and T's are crossed, they are granted. Now, the beauty about the system is that you save an enormous amount of money as an applicant. No challenge guaranteed, done. 3.5, I think our record is 2 months and a week from filing to grant. And these things have teeth. They have teeth. They're valuable. They're worth filing. Again, take that alternate universe concept. Let go of what it is that's constraining us, right? About our own U.S. experience and the expectations we have. Get those cases, but it's not just simply a matter of filing. You've got some challenges when it comes to enforcement, and we found that through some personal experience. It hasn't always been so positive. The Chinese courts tend to take a very exacting view of infringement. I mean, they're looking for a virtual photocopy of infringement. That makes your job tough. We are looking for, in China, patents that are easy to get but tough to invalidate. This is generally true about design patents, utility model as well. You've got some prosecution issues when you do file, so it's not simply a matter of taking what you have and going abroad. And I know Alan and I have had this discussion about some of the drawing issues. So it's not simple anymore. It's not simple about their functionality. This discussion doesn't really help. But the drawings discussion. We're used in the U.S. to filing our line drawings. We file our line drawings, and U.S. Patent Office likes that. Chinese Patent Office and other offices around the world are not that partial to line drawings. They want to see 3D CAD images. They want to see photographs. And third on their list of favorite drawings, the line drawings. It's upside down from US practice. Working with our auto company client, we've had a difficult time in the US sometimes advancing 3D CAD, even though we have the images right there. They're already produced, already generated. Our line artist doesn't like this whole deal, but now he's learned CAD, so that's worked out real well too. He's got a whole new opportunity to send us invoices. And that's really worked out. But convincing the US examiner that CAD images are really useful it was a tough way to go. And most companies already generate these things. I was in Beijing arguing with an examiner at SIPO, a design examiner, oddly enough, because he didn't understand our figures. And I took with me on my laptop my 3D CAD, and I probably violated a dozen of the firm's rules about taking the stuff with me. And I had it. I sat there with the examiner and his speed, and we just went over it, rotating the view. These guys were having a blast because it was a live image, and we were able to capture the view that was missing. We got it resolved. It was very good, and it was very successful. But that's the kind of flexibility I think that we need to be able to maintain. How do you solve that, by the way? Earlier on, when we began extending our US cases to China, the design world, and we had trouble with these line drawings, we were finding that things like broken lines and shading, Chinese Patent Office not only didn't like, but didn't permit. So you're thinking, no problem, I'll go ahead and fix that. Then you fix it, you either make a continuous line, you remove something, and now you find that the Chinese Patent Office is rejecting the application because you introduced new matter. And check your malpractice insurance because you just lost your priority date. See, those problems, fortunately we've managed that because now in many cases we have dual filing, both our CAD images and our line drawings when we file the US, and then when we extend overseas to different countries, depending on what the preference is, we'll cancel one or the other. But this way you get our priority date. It's a good strategy to have and also protects your, it saves that call to your general counsel. You know, boy, did we screw up today. Functionality is a real different discussion in China and other parts of the world, but again, I default to China. Because we have filed things and got granted it actually enforced things like alternators, gearboxes, windshields. Now, last time you checked under your hood and if you could manage to find your alternator, there's not a lot that's really, I don't know, maybe, I mean, I'm a car guy, but I really don't get the whole aesthetic thing about an alternator. That's gorgeous, right, Barry's right, it's gorgeous. It's on the eye of the beholder, right? You put enough chrome on there, it looks great, it's a show car now. Nope, we could defend those things. I had a discussion because we were filing some cases for a client and they came back, their chief patent counsel didn't realize what we were doing and came back and said, Tom, you know, we're trying to defend the US approach to limiting functionality. Here you go filing these things. I said, but we can. Because a case not long ago in the fall of last year, summer of last year, dealt with the design, validity of a design patent that was on a bearing for a marine engine, an outboard engine. Now, if you can dig into the engine far enough, I could pretty much guarantee it's totally functional. Whatever the bearing was doing without even seeing it, I can guarantee that thing was just pure function. The court upheld the decision. Now, in China, one court doesn't have to list to another, and so that may not mean anything in Beijing, even though it meant something in Shanghai. So you've got that challenge to you. But I asked our counsel out there, who is the person in a position to know this, and I said, what's the story? We're hearing different news about functionality in China. He said, well, funny you should say that because we haven't decided ourselves internally. There are those inside SIPO, the Chinese Patent Office, State Intellectual Property Office, who want to follow a US model and restrict the amount of functionality in these cases. But he said there are others who just look at design patent as a low-cost entry of individuals and poorly funded small enterprises to get into the game, and they're going to defend it. So I wouldn't look for that system changing anytime soon. I think that it's just going to be, now having said all of this, I'm a great supporter of using the system. You can file cases in China and get them granted and stuff you can't even cover here. Today's good law. These cases are valid. Low cost. Your client's dealing with the low, we've got only so much money to spend. Here's what we do. I've got a gift for you. And in China, we could join the 400,000 patents being filed every year by the Chinese. Soon to grow. What else can you do? You've got your design. You're in your alternate universe. We're all thinking right different now. You're off this highway that's north-south. You're on kind of one that's east-west, right? Let's take it one step further. Utility model in China. Utility model patent. The UMP is called. Much maligned. That is the most popular patent in China today. Being filed by Chinese. That's the bulk. A patent that was modeled from the German patent law. Because back before China's patent law came into effect on April 1 of '85, China relied heavily on the German patent system to figure out what to do. China looked at the German patent system that included at the time and still does, a petty patent, a simplified patent, a sort of, with all due respect, a dumbed-down version of an invention patent. Claims are supposed to be directed at simpler invention. It's not how it works, by the way, in China. But that's what it's supposed to do. And it was introduced into the patent law back then because it was aimed at the same thing the design patents were, at servicing and enabling low-cost, poorly funded companies and individuals to get into the game. But now the system has gotten drunk on it because the bulk of the patents being filed, it was never intended this outcome. And my same friend who was involved in the drafting back in the late 70s said, we never intended this outcome. But how do you put that genie back in the bottle? It's not examined. It's just filed. And unless something is really amiss, it issues within 8 months. You can file an invention patent at the same time. Get your utility within 8 months. Your invention patent issues 2 years later. And in the meantime, you've only got the window of 8 months where you're not protected. You can't have both, by the way. You've got to pick one or the other at the end. But what do you care, right? You've already arrived. You've got something that offers protection. Easy to get, hard to invalidate. Hard to invalidate because we've been challenged by these things, and we've spent tens of thousands of dollars dealing with these utility model patents that probably would never have been granted if there was something to be examined. But just to make it go away, you're looking at dropping $20,000 or $30,000 just to get these things to go away. It's very expensive. To invalidate a utility model patent in China, you can use no more than 2 references on a claim. 2 references. That's pretty tough to invalidate. I have trouble doing that in the U.S. Examiners have trouble doing it in my applications in the U.S. when it comes to getting these things filed. Easy to get, tough to invalidate. They do have teeth. They're worth enforcing. They're worth getting, that's for sure. Because you can use them as a bargaining chip against the other company that has a utility model patent they want to bring against you. So now I've got something you could use as a prisoner exchange, so to speak. Last thing I just wanted to mention is the part that we've had most fun on recently, and that's copyright in China. A discussion here about the relationship. We learned early on, working with the client and having a discussion with the director of copyright about this, that you can use copyright system in China in ways you wouldn't begin to think about using in the U.S. Now, this is not a parallel universe. This is truly an alternate universe. Because you can get design protection on something that has, you've got, of course, you get something that's fine art, that's accepted, something consistent with U.S. practice. But you can get protection on works of industrial art. One of the earliest cases is a lantern case out of Xiamen, southeastern China, which tends to be pretty progressive. In that Fujian province tends to be pretty progressive in China. They're certainly over the mountain and far away from the emperor down there, so they do what they want in some ways. And it was copyright. The design was, it was too late to file a design patent protection for this case. It was publicly known. 10 years, 15 years. You're capped at 25 years, by the way, going this route I'm talking about. But they've got a copyright registration on it. They enforced it and they won. Industrial art, a work of industrial art. U.S. Copyright Office would never go along with this. There are differences in thought, see. There are ways to go about that. I talked with the director of design when we were initially looking into this to figure out how to handle it. And he gave me the case of his famous Michelin case. The Europeans, the French, I give high marks for this. They filed design protection on a tread for a Michelin tire. Again, functionality, who cares, right, in China. And they also simultaneously filed a copyright registration on the same work. They use the same images, in fact, in the copyright registration. And they went to attack an alleged infringer. It never went to court, unfortunately. It's one of those kind of things that, we would love to see to go to court so we know what the parameters are, at least for that given court. It never went to court, but the defendant backed down, plaintiff backed down, based on the protection that, no, it was I'm sorry, it was Michelin that was in the driver's seat here. The defendant backed down and completely changed their tire design, which is not inexpensive to do, by the way. Changing a mold would be costly. And they went ahead and switched it out because they knew that this, either between the copyright or the design, they were cooked. But Michelin wasn't even putting its design at risk. They only saw it under the copyright. And it showed that it had teeth. And the director of design knew about this case. But he also said, Mr. Mogul, like everything else in China, what happens in Shanghai may not happen in Beijing. So he warned us that because, of course, they have to listen to each other, you could be out. Anyway, that's my alternative universe, my parallel universe.
Thank you. I think we have just a few minutes, but definitely want to open it up for questions.
I'm a huge supporter of design. For me, file early, file often. And it's a relatively, and I know it's more costly in the U.S., and Rob could certainly, as a practitioner, speak more to that. I get a chance to carry his briefcase to design programs because he knows this area so well. But in this area, I know I always encourage our clients to file. And China is inexpensive. Extending, and not just China, but Europe, extending the protection elsewhere in other jurisdictions is, once you have the drawings finished, that's really the high cost. And once you have those finished, then it's pretty easy to extend. I'm a big fan of using them as an offensive and defensive tool, and using them for horse trading.
Yeah, I think it was touched on a little bit this morning, but in almost every case of design patent infringement, either decisions or in enforcement matters short of a legal decision, it's almost always the accused infringer is copying the commercial embodiment of the patentee. So getting a design patent right, like a utility patent right, hoping that the more they practice, they'll eventually hit it. That practice doesn't really exist in designs like it does in utility patents. So you see a lot of people, getting a war chest of utility patents because eventually they're going to step into our field of landmines. That doesn't really happen in design patents. Now that said, if you're commercializing a product, or plan to commercializing a product, you should thoroughly protect it with design patents because you don't want anyone copying what you have. But I would not procure. So if you created 20 different designs and you're going to commercialize one of them, I wouldn't bother to file on the other 19. I save your money and make sure you have your best protection for the ones that you're going to commercialize.
Having said that, in China the law has recently been changed so that you can file multiple configurations in a single application. There's a certain danger in that because now you've got the single application with multiple configurations. But Rob's right. The greatest problem we face, at least with my auto client, is that 20 minutes later they're changing the design. And they'll change that design right until a couple days before production. And now what do you do? Because I have something that's similar but not the same. And those are tough questions because you're starting from scratch again. Tough questions. As much as the pocketbook, the wallet will allow. The problem we face is that when I go to a client and say, we have to get everything of yours protected in every country on the planet, for some reason, which really, because I'm thinking bonus, right, we can get this done. It just doesn't work out that way. And what we have to demonstrate is understanding they've got a fixed amount here. And if we're going to say you need to file more in India or in China, that money has to come from somewhere, and it's probably not going to come from new money. It's going to be shifted money out. So we have to make an argument that look for lower cost ways to protect, which is why I am a fan of the utility model and filing multiple cases in China because so much counterfeiting is done there and manufacturing is done there. So both defensive and offensive purposes.
Mm-hmm.
Any jurisdiction beside China, like multiple designs, anything like full
In China, you can. I don't know about others. I know that where
Well,
else
I
can you
mean,
do
it's different. In a lot of countries, they have what's called collective design systems. So you have one umbrella and a number of distinct designs within that. And in a collective system, each design has its own rights and for issues of and scope for validity and infringement, and you can choose to renew some and not others. And there's a lot of countries, more and more countries have collective systems. But then there are some that let you sometimes put multiple designs in the same case. And there you really have to look, because some of these jurisdictions, if one of the designs go, the whole application goes. So you have to be very careful about doing that, trying to stick multiple designs in one case. So, but yeah, more and more countries are permitting either multiples or collectives, and you just have to make sure that you, before you file in any jurisdiction, you really have to know what the law is in that system and the parameters and how to best achieve your protection goals.
cost savings for risky?
Well, yeah, you can have multiple designs in a single U.S. design patent, but they have to be patently indistinct. So there needs to be very, very minor variations, and even then there may be a benefit to not having them in the same case. There's a fiscal benefit to having them in the same case, but there may be it may be better to have them in separate design applications for separate design patents to have more enforcement options.
Yeah, I'm just curious about your experience in the East, in Asia, with regard to protection of intellectual property in general, because we're talking about the roots of protection of intellectual property in the West based on monasticism, and in the East, is a reliance on the wisdom of the elders. Contemporary inventors don't have to respect the being the best. Do you have any comments on that?
I mean, I don't have any real philosophy on the history of why things are there in the different countries and their different social philosophies and how they intertwine with the systems. I think in a lot of these Eastern countries, they have developed their design patent systems pretty well, and they have looked at the laws in the rest of the world, and they have pretty much advanced those. And I don't know how much of the old. I mean, obviously, it's good to know if there's any particular peculiarity with customs in any country. So you want to prepare things differently, but I think generally speaking, you can get pretty good rights in a lot of Eastern countries.
My experience with what we found in China, for example, their law is really a quite good law. It's the amended law, the most recent one, October 1 of 2009, really moved the law forward, but it parallels in so many ways. Laws of India, of Brazil, of U.S., and really Germany is where it's got its roots. So I don't see that enter into it. And I'm not really sure that even in litigation, I mean, at one time, there was a thought, we were having this discussion at lunch, that, well, there's a certain amount of, let's work this out. You know, we have a dispute, let's work it out. But the skyrocketing amount of litigation in China, which has really been driven by Chinese versus Chinese, we were all a bit surprised by that, because there's this tendency to let's negotiate a reasonable solution to this. So what I thought was a cultural attitude entering into litigation, either it's a small group bringing a lot of cases, which is possible, but I see a sea change here. I do see a difference in attitude, and so I tell my clients, I said, this is during lunch, we had this discussion. I said, this is not your father's China. I can't say about Japan or Korea, we don't do much litigation, but certainly in China it's a different animal, and I don't see the culture entering into it as much.
And there's a book written by a Harvard professor about that.
What's the title? Do you know?
It's something on the order of not steal this book, but...
Elegant Offense. It's an elegant offense to steal this book, yeah.
Yes, exactly.
Okay, thanks very much.